In a common sense, the law of tort is the branch of law controlling the behavior of the society. However, the characteristics of tort are as follows. It is a civil wrong in which legal rights of a person are being violated. Is different from the breach of contract or breach of trust, and it is redressable by a civil action for damages. And the quantum of damages is being determined by the court. History of tort. During the early years of 14th century, the simple procedure for administration of justice was being done by the British king. So the administration of criminal justice was vested with the king's court, and action for trespass and other civil wrongs of civil nature were to be adjudicated by the common law courts, otherwise termed as the courts of common pleas. So if one's rights are being violated during the early days of common law, so one can only bring an action.
One speaking from the background now. Go on. Somebody is speaking from the background.
Hello, can anyone hear me?
I'm hearing you. Go ahead. I'm trying to tell your members who are not concentrating.
Okay,
Go
sir.
on.
All right, sir. Under the system of writ, the plaintiff had to comply with a formality of obtaining writ from the chancellor, in the sense that a situation by which someone's rights had been violated, he can only come to the courts with a writ of given by the chancellor of the exchequer for instituting a suit against the defendants in the common law courts. So if the wrong comes to a remedy, the chancellor would issue a writ entitling the plaintiff to file a suit against the defendant. So a plaintiff cannot just come to the common law court without a writ in a situation wherein his or her rights has been infringed on. So the plaintiff had no remedy. The plaintiff had no remedy, though he might cause a cause of action. So when a plaintiff comes with a writ, that is the only way that his civil wrongs can be addressed at the common law courts. So in the course of time, other types of wrongs such as negligence, nuisance, or disturbance in another's possession of chattel also called for a remedy. Modification of the writ system, as stated above, so I will move to the next subtopic, which says purpose of tort. The main purpose of tort is to provide a remedy to individuals and legal entities whose legal rights have been infringed on. The remedy usually comprises of damages consisting of sums of money intended to compensate for personal injury, property damage, or economic loss. Damages have a compensatory purpose to correct wrongs. So they are designed to restore the plaintiff to their original position. Classification of torts. Torts can be classified according to, in line with our work. There are so many classifications of torts, such as right to physical integrity, right to freedom from serious and unreasonable interference with mental integrity. So right to privacy, which is relatively modern and has received scant protection at common law. Legal interest in freedom of movement. The right to personal liberty to lawfully choose where to be and which way to go, to protected by the threat of false imprisonment. Right to use of land and rights to free belief and opinion. Sorry, permit me to move to the objectives of tort. There are so many objectives of thought,
All of these,
which are as follows.
all of
Compensation.
those
The law
things
of thought
are not relevant.
seems
My sister, all of those ones you are talking about that are not relevant. Go to the theories themselves. I'm sure that every one of us did thought at Ll.M. Go to the theories of thought. Because you didn't discuss theories of thought.
Sir, I'll take over
yes,
the
we
theories of
discussed the
thought.
theories of thought, sir.
Why? Why do we
Blessing,
have
I'll
thoughts?
take over. Sir, that's at page 25, I believe.
Yeah, page 28.
The theoretical
Page
basis,
28, yes. Page 28.
Part 4. 1 second, please.
That's all we need in this class. Every one of us knows thought. We know the history. We know how it was received in Nigeria. Every of the things you are saying, beautiful, wonderful, but we already know it's thought.
So Prof, we say that
allowed to exist as a separate subject area. Speak to theories of thought law in not more than 20 minutes, please.
So, Prof, we state that the objectives of thought are tied to, number one, corrective justice, which by definition is that the idea of thought law exists to correct moral wrongs when one party injures another. Key thinkers of this theory are namely Aristotle, and this theory is mainly based on his book, which was the Nicomachean Ethics, I believe. So the core idea of corrective justice is that when one is wrongfully injured by another, then justice demands that the injured person be restored to his original position by the tortfeasor. That is the person who has committed the legal omission or the negligence, who has been negligent. So from the corrective justice, we move on to distributive justice, which focuses on how the law can distribute benefits and burdens across society. Proponents of this include John Rawls, and the core idea behind distributive justice is that tort law should contribute to social justice by considering broader societal implications, for instance, access to justice and with regard to economic disparities. Its application influences decisions about strict liability, compensation schemes for widespread harm, and that would include medical negligence. Then, sir, we move on to the economic law and economics theory. And a major proponent of this is the American Guido Calabresi. And here he states that tort law aims to create efficient outcomes that should minimize the total cost of accidents. And what this aims to do is that the law will look at the economics and put such, should I say, not necessarily punishments, but in terms of compensation and payment of damages, such that people will be discouraged from committing these torts. So the application is supported in negligence to promote cost-effective precautions, such that even in corporations. Hello, Prof. Hello, sir.
We stop hearing you. I'm now hearing you. Start from economic theory. Start from the beginning of economic theory.
So I stated that the major proponent of the economic theory is Guido Calabresi, and we have others like Richard Posner. And this theory is based on the fact that tort law aims to create efficient outcomes that minimize the total cost of accidents, is mostly applied with regard to corporations, major corporations, pharmaceuticals. And the whole idea, sir, behind this is that damages should be spread out in such a way, sir, that the people consider that they need to put systems in place so that these torts will not be committed in the first place. So the whole idea is to create efficient outcomes that minimize the total cost of accidents. So corporations are encouraged to promote cost-effective precautionary measures within their establishments. Another theory, sir, of thought is deterrence. So here, this theory is closely linked with the previous one we just talked about, which is the law and economics theory. And it states basically that tort law deters harmful behavior by making people and companies internalize the cost of their actions. So this is why it's closely linked with the law and economics theory. They are deterred. They are, should I say, forced or compelled to put structures in place to avoid the cost of damages. So in this way, they are deterred from committing torts. Then, sir, we also have the compensation loss distribution theory, which basically states that tort loss serves a social function by compensating victims and distributing losses fairly. This is also closely linked with the first one we discussed, which is the corrective theory. But the emphasis here is on compensation. It's not merely to restore the victim to its original position, but to ensure that he's compensated. So the core idea is that the burden of harm is shifted from the innocent victim to those better able to bear it. And this is applied mainly to insurers and manufacturers. So the application is seen in doctrines like vicarious liability and no-fault compensation schemes, largely used in the US. Then, so we also have a retributive justice, moral accountability. And here we say that tort law expresses moral condemnation of wrongful behavior, holding individuals accountable. And this is quite similar to criminal law, however, in a civil context. And my colleague would have talked about the difference between tort and criminal law. So though it is similar to criminal law, the burden of proof is also a civil one. It's not beyond reasonable doubt like we have in criminal law. So some wrongs deserve redress as a matter of moral principle. So the application is particularly relevant in intentional torts like assault and defamation. So we see a correlation between this type of torts, this theory rather of torts and torts that have a criminal underpinning, like defamation, assault, and false imprisonment. Then, sir, we also have the right-based theories. Here we say that tort law protects individuals, which this is very closely tied to the objectives of tort. So tort law aims to protect the bodily integrity, property, and reputation of individuals. And we have as major proponents people like Jules Coleman. And the rationale behind this is that torts are about violations of pre-existing legal rights rather than merely managing harm or incentives. So, sir, I don't know if we can say that the theory of damnum sine injuria should fall under this, because even where there is no injury, we want to say that a right has been breached. So the application is on fault and rights violations rather than just economic losses. And then, so we want to also say that you can see the relevance of these theories in matters of negligence. So, for instance,
Go on.
okay, for instance, negligence, we have that corrective justice fits negligence neatly into its fold. When somebody breaches a duty of care and causes harm, they must restore the injured party through compensation mainly to their original position. So the focus of the moral relationship is on the focus rather is on the moral relationship between the wrongdoer and the victim. And then talking about economic analysis and negligence rules encourage cost-effective levels of precaution. This applies mainly to corporations. if a party is liable only when they fail to take reasonable care, they are incentivized to avoid accidents only to the extent it is cost effective to do so. But the focus here should be, I'm talking about economic loss and negligence now. The focus here is on the moral relationship. I'm sorry. So they are incentivized to avoid accidents only to the extent it is cost effective to do so. Okay. So deterrence and negligence. People are encouraged to act with reasonable care. Then the fear of liability also motivates safer behavior. When people know that, I'll give an example, and that would be even for, I don't know if it's a good example, Prof, but it's for people with children, for instance. I want to believe that it's taught is a deterrence where one with a child understands that they should not allow their child to throw stones at cars, because then they will be liable if there's any damage. So from negligence, I'm going to move to strict liability. And here we talk about the fact that with regard to strict liability, the burden of injury shifts to those best able to bear it, which is often businesses or manufacturers who can pass on the cost through insurance or pricing. Then that's with regard to compensation and corrective justice. We're bundling the two together now, since they're quite similar. Then with regard to economic theory, even if a party is negligent, strict liability encourages internalizing the cost of harm, and it shifts the burden. Okay, it makes producers rather more innovative for safer products and to improve their quality standards. Then talking about strict liability and distributive justice, this goes also with product liability, and it ensures that consumers, usually the vulnerables, are not left uncompensated when harmed by larger corporations. Then lastly, sir, we talk about intentional torts, which is closely linked to crime. So we have assault, battery, false imprisonment. And with regard to the major theories here are retributive justice, right-based theory, and corrective justice. So with regard to retributive justice, it's applicable in intentional tort because these torts are morally blameworthy and deserve punishment or moral condemnation. Civil remedies serve both to compensate and to censure. So the right-based theory, these thoughts protect fundamental rights, bodily integrity, and freedom of movement against assault, false imprisonment, and battery. So liability is based on the violation of personal autonomy, not just harm. Okay, so one more. Corrective justice. The wrongdoer corrects the harm done to the victim through monetary or injunctive relief. And then the last one we shall talk about is defamation. And then the theory linked to, most closely applied to this is the right-based theory, corrective justice, deterrence. And under right-based theory, it states that individuals are the right of individuals to a good reputation and dignity is protected. Then under corrective justice, we state that the injured parties are compensated for damages done to their reputation. The wrongdoer must rectify the harm. Then, as by way of deterrence, the tortfeasors or would-be tortfeasors are discouraged from spreading false information or slander. So there's a couple others with nuisance and vicarious liability, and it's all the same application: corrective justice, economic theory, and distributive justice theory, sir. That's what we
Very
have under
well.
the theory, sir.
Very well. Now, the aspect of your discussion that I like most is where you are trying to suggest that different aspects of thoughts will probably be explained by different theories of thought. You understand what I'm saying?
Yes, sir.
Different aspects of thoughts will be justified by different theories of thoughts. Are we then to say that the theories should be taken cumulatively in terms of their efficiency or usefulness, that no particular theory is capable of explaining all aspects? For example, like you have told us, the idea of retribution is the reason why some thoughts are damnified. For example, defamation. If you will publish false and a reputation damaging information about someone, then you should be ready to bear the cost. The cost to his reputation by paying him compensation. Okay? So a particular theory will explain that. On the other hand, we have strict liability thoughts, where you really cannot place the fault on anyone, as we saw in Ireland and Fletcher and the line of cases. But the concern of the law is that this is an injury that is well beyond the capacity of the bearer to correct. And if anyone has to correct it, if anyone has to effect correction with regard to the injury, it has to be the person who, rightly or wrongly, directly or indirectly, is regarded as the actor or the omitter. And so for that reason, the excuse that I was not at fault would not even be accepted. Whereas there are some other thoughts that your fault will have to be established before you can be liable. So each of the different theories would explain different types of thoughts. And so it is the totality of the theories that will explain the reason why we must have thoughts, why thought must exist as a course of action. Okay? We don't have much time to discuss this in your paper, but can you tell the class members now your particular readings? Because I saw that when you were discussing the theories, you did not even indicate footnote for us to be able to see what more we could read. Do you understand?
Yes, sir.
Hello?
Yes, I'm with you, Prof.
Can you give us the materials that your class members will be able to read for each of these theory or for all of them?
So most of it.
I didn't see any
Yes,
footnote. Civil record theory, nothing to indicate. Or is it one textbook you read where all of these were discussed?
So most of it was based on arguments in theory, thoroughly modern thought theory by J. Zipurilsky and I. Goldberg.
Please indicate that on the WhatsApp group.
Yes, sir.
Indicate it on the WhatsApp group so that people can go and read it. Okay?
Well done, sir. Will do, sir.
Okay. Let me see any other thing. So you listed how many theories now? You listed corrective justice, economic theory, but in economic theory, you mentioned the name of the proponent. Did the proponent not write a book? Richard Posner.
Guido Calabresi.
Yes. Did they not write any book?
I'm aware that Guido Calabresi wrote a book, but he was in Zipronsky's critique. That's where he talked about Calabresi. That's where he mentioned Calabresi's work. So I didn't read Calabresi's work myself, Prof.
Okay. Deterrence theory. Just like in criminal law too, the usual hallmark of deterrence is that you want to impose you want to make the consequence to be higher than the wrong itself, so that the doer, when he considers what is going to be required of him to right the wrong, will not even contemplate doing it. That's deterrence theory, whether in criminal or in
sentencing on the criminal on offenders.
Okay. There's a footnote there. Abi, is it my eye that is seeing double? Let me put on my glasses.
Yes, sir, that's just saying that punitive damages may be awarded to serve a strong deterrent signal.
Yes. What types of thought will you link to deterrence theory? What type of thought?
I would say most thoughts, starting from even defamation, all the way to product liability. Almost all thoughts require. Sir, did you say compensation or deterrence?
I'm talking of deterrence theory.
Is,
which thought will you link with deterrence theory?
Most thoughts are across board. Most thoughts are across board, because the whole idea is that people would put structures in place to prevent the thought or to prevent the act or omission. So
hello, sir.
basically all.
I want to contribute, sir.
Okay.
Yes, in deterrence theory, one of the major proponents is Jeremy Bentham that also talks about pendulum, where the profit that the offender want to make will be jeopardized. And then we have specific deterrence, we have general deterrence. And then example of such thing can be alluded to street liability, even battery. So that will discourage people who want to perpetuate along the line. And thus, we serve both specific offender or thought figure and the general person. Adede Jadefura is my name, sir. Thank you, sir.
Okay. This is retributive theory. An eye for an eye.
Yes, sir.
Can a thought that is explained as a demonstration of deterrence also be a demonstration of retribution. Because if you want to do retribution, you talk about measure, an eye for an eye.
Yes,
Yes.
sir. Yes, sir. Thought is interwoven. They are interrelated. They are overlapping, and that is why deterrence and this retributive theory of justice are somehow similar in a way. So when we are talking about, for example, a rich man commit a crime, and then we have to look at the amount of financial strength he has. So if judge is going to award any damages, he's going to award it according to the financial strength or the gravity of the offense. Similarly, to somebody who committed a very minor or minute offense. So that is why we can say these things are relative and interwoven, sir. Thank you, sir. I don't feel I didn't use my name, sir.
Philosophically, deterrence as a moral, as a basis for punishment has nothing to do with retribution. Reason being that deterrence, as the name implies, is to deter people, as the other speaker said, both generally and specifically from committing a crime. But retribution, on the other hand, is to punish. So with regards to tort here, it's we may say it is interwoven, but the truth here is that when we're applying this theory in torts, the compensation that is expected to be paid in damages by the tortfeasor is supposed to be very punitive. It's not just supposed to be a paltry sum that he can pay and walk away. He's supposed to feel the pain. That is how I would apply it to torts.
Sir, thoughts.
Can you give me an example of thoughts that can be cited as being based on retribution? As opposed to deterrence.
Sir, I cannot. And the reason I cannot is that even the writers are averse to this point, being that they see it as an anachronistic theory that should have no place in torts. So I really have not come across anything
Hello,
other
sir.
than the fact that it's moral condemnation aimed at punishing the wrongdoer.
I want to mention that torts and criminal law, they share a boundary, just a very tiny line. If we are to look at the rule in Smith and Schilling, 1914, it was mentioned that before a criminal suit is being initiated, the first thing that will come is the criminal aspect of it. So if we are to mention that area which you are trying to inquire, sir, you will see that the intention is to make sure that eye for an eye or teeth for teeth is being carried out, not in order to discourage people who want to take people for granted. We are talking about thought, and thought has to do with the private aspect of human life. It is through law that, through the law made by the state, that is the standard that we are expecting from every woman. But in criminal law, it is being made through statute, criminal code, and penal code. And that is why, according to that rule in Smith, it is expected that somebody should initiate the criminal aspect before the civil wrong, the civil aspect. Thank you, sir.
Very well. The point I'm trying to make is that when you are applying retribution as a sole theory for thoughts, then you must not keep your eyes away from the test of proportionality. There must be a way of measuring what the thought we saw will lose vis-a-vis the harm he has caused the victim. So whether it is criminal law or tort, retribution simply means if it causes X damage, it will compensate to the extent of X. But some of the time, deterrence might mean more than retribution. You want to prevent somebody from doing something by imposing a consequence that is higher than the loss that will be incurred by the victim of what they. So deterrence and retribution, they appear identical, but the element of proportionality is the difference between the two. So when you are applying retribution, I mean, there is this joke about somebody who was arrested for stealing and was saying, "Thank God, I only stole, I didn't rob." Reasoning means that he knows that the punishment for stealing is different from the punishment for robbing. So that's from the very first code, which some people say is the Hammurabi Code. Okay? It has always been the measurement of an eye for an eye and a tooth for a tooth. Okay? But deterrence might actually mean 2 eyes for 1 eye. Okay? Because the punishment might be higher as a way of deterring you from doing it or deterring others who will watch you suffer that punishment from committing the same wrong. Okay? The assignment I give to you is that go through the whole gamut of thought and see in what subject area of thought can we say that the motivation for damages distribution, but deterrent. Okay?
Hello, sir. Can I add one or two things, sir?
Yes.
From my observation, sir, that retributive theory of justice can only be applied in criminal law, sir. More because of we are doing sentencing and the treatment of offenders. We did thorough in-depth study in that area, sir. And then we observed that that retributive justice can only be applied more in the criminal aspect of the law. But in the theory of law, thought aspect of the law, like state liability, occupier liability, detinue, something like that, one will want to apply such theory or law, but it cannot measure up like in the criminal law aspect, sir. That's my observation, sir. Thank you, sir.
Well, there's no way that opting for civil claim would be exactly the same thing as settling for punishment. In the very first instance, the motivations are different. So the measure of proportionality will differ For example, we are looking at the victim's loss and telling the appellant to make good that loss. So the peculiarity of the victim becomes important. It may well be that the same wrong done to another victim would have been cheaper to redress. Would have been cheaper to redress. So I think that is the area of difference. The measure is social or public. The entire society, the or the wrong act of, and at a, but in thought, you can slap one person and they can slump, but the same slap might just cause some irritation or some small discomfort to another person. And so in determining proportionality of compensation, the test will have to be private, will have to be subjective, will have to be personal in the area of thought. But in criminal law, it is the public that places a value, a measure. The only thing is that through that measure of punishment, you are able to determine how the society ranks misconduct. So the society possibly saw that stealing is bad, but it's still better than robbery. Okay? The society probably saw that indecent assault is bad, but it's still better than rape. Okay? So this informs the variation in the punishment that is given in each case. Okay? So the yardstick is based on public or social value or measurement. But in the case of thought, you have to bear in mind how the wrong conduct have. And so you cannot be using the social or public yardstick for measurement. You are looking at how it affected the individual. Of course, they taught us in thought, causation and all of that. But two persons will not suffer the same consequences from a strike or a slap. Okay? So, that to me is the difference between criminal law and civil law when you are talking about retribution. Okay? But what I'm saying is that from the very meaning of the two theories. Deterrence and retribution are not the same. Retribution will emphasize proportionality. Deterrence might want to impose higher consequences far greater than the injury, as a way of deterring the thought we saw. Okay, what I have not sat down to look at is which are the typical examples. Okay, and so any other contribution?
Yes, sir. The eggshell principle fall under what you have said, sir.
Yes, you take your victim as you find him. That applies to both criminal and civil law. Okay? It applies to both criminal and civil law. You do not say, blow I gave to him was and then a little and came back to his feet. But in no case, he spent 3 days in the hospital. Okay? You must take your victim the way them. That's the eggshell principle called principle. So what point were you trying to make out of it? Hello? Mr. Last Speaker, what point were you trying to make?
Yes, it has relevance with retributive justice. Like you mentioned that somebody will slap somebody will slump, another person will slap, and nothing will happen to the recipient. So that's what I'm trying to support, sir. Thank you, sir.
Okay. So she will give the particular material discussing the theories, and your assignment will be, after understanding each of the theories, which thoughts can you use to illustrate each of them? The economic theory you can use to explain, corrective justice theory you can use to explain, say, strict liability or absolute liability thoughts, where you cannot place fault on anybody, but somebody has to bear the cost. And so, who else will bear the cost other than the person who had the misfortune of being associated with the thing? That looks like an explanation of economic theory. Will simply be talking about, as far as the society is concerned, on whom shall we place the burden of doing this thing? Who shall feel the burden? Who shall have the least feeling of the burden? And that informs by cross liability. A wrong has been done. We know the thought we saw, but we know he's the employee of someone. If we are to tell him to be the one to bear the consequence, then the wage will be too much for him to bear. And we have seen occasions when people have said, look, I prefer to go to jail for this because the cost of redressing it I cannot find. Okay? But if you place the body on the employing organization, giving the enormous resources, okay, the cost will just be like a footnote. Maybe of his profit. Economically, both the body of prevention and the body of reasoning is better placed on the head of employer than that of the employee who actually committed the wrong. So that is a theory that explains vicarious liability. So look at the theories. In some textbooks, there are more than this. But even the ones that she has given us, see what types of specific thoughts we use to illustrate them. I can't see any criticism. Why did you not do a critique? Hello?
Sir, if I'll be honest with you, it was a little bit confusing to do a critique. So that's the main reason. And I'm going to tie this with the question you asked, sir, when you asked whether or not the theory should be taken cumulatively, because when we studied the theories that we studied, we saw that every should I say every proponent or every school would criticize the other, and that's why we couldn't harmonize it. But in our recommendation, we simply stated that, just as you asked, that all the theories should be stated cumulatively. That was the only way we could define it. But sincerely, it was a little bit confusing.
We will benefit from the critics. We will benefit from the critique of each theory, not that we will accept the criticism hook, line, and sinker, but they will help us understand the theory themselves. Okay? But it's good. Once you give us the material you consulted, everybody will go and read it and see for restorative justice as a theory, corrective justice as a theory, deterrence as a theory, etc., etc. Economics as a theory. What is it that can be said for this, and what is it that can be said against it? Is when a jurisprudence class, and those things can also count. Okay? So I think on that note, we can take this topic as covered. Mr. Adediwura.
Adefowora,
You can post whatever you have done. You can post whatever you have done. Let people see whether there will be anything we need to add to this.
Yes, I have done that already, sir.
I have decided on your feet too, but you can post it.
Thank you, sir. God bless you, sir.
Class governor, please. Let him post it on the WhatsApp group for whatever it's worth. Do you understand? I will take my decision when.
Yes, sir.
When we before the exam, I will announce my decision on the matter. Okay, but the impression that we had was that is either you didn't have it or you wanted them to do it so that, which is what always warn the group member out. Because these seminar papers, you all have the same score. Imagine how this contribution you are making, if you had made it when they were doing the paper, imagine how useful it would have been. Do you understand? So just send the paper to the WhatsApp group and let everybody look at it, and let the main presenters send the relevant bibliography on, especially on the theory.
Yeah, thank you, sir. Thank you, sir.
Yeah. Okay.
Okay, sir.
How many more topics do we have? We have contract theories of.
Sir, yes, that's group 9. They are ready to present. You said we'll take the theories today, the group 8 and group 9. Then next week, we'll take the other mental basis. So if group 9 presents today, we still have 7 more topics to present.
7
There
more
are
topics.
17. Yes, sir. There are 17 seminar paper topics.
But I've seen that you are putting some 4 or 5 people in some groups now. How many are we in the class?
No. I have to check. It's what I sent to you that is being there. For mental basis, they were there.
No, like this paper now, there are 5 people now.
And
No,
there are
okay, this
some
third
people
paper, there are 3. But contract, there are 5 people.
and okay, thought was 4. The one they did was 4. So the seminar paper they sent was 3. Adefora was the group leader for this group 8. So for group 9, it was 5. It was one of them, those candidates that you said I should include when the person came to explain to you. So that was what made it to be 5.
Did the candidate contribute in the paper, or did they just accommodate
I believe the
him or
group
her?
leader can speak on that.
Who is the group
Olamide
leader?
is the group leader. Olamide
he contributed.
Yes.
Okay.
Everyone contributed.
For me, it's almost 7. It's almost 7. I can't take anything today again. You finish by 7:05. I say my prayer. Okay. But what I can tell you is that when you are going to present this paper next week, you will start from part 2. Your part 2, the theories you mentioned there, theoretical foundations of law.
That's fine, sir.
Theory, economic theory, social theory, declaratory theory, expedition theory, and we won't give you more than 30 minutes to do that.
That's fine, sir.
Okay, all of us know law of contract. We know contract remedies. We know all of that. we are going deeper in the jurisprudence class to say why should there be a subject area known as contract? Do you understand? Why should there be a subject area known as contract? So it is only part 2 that you will need to go through. We will read the rest, but go through part 2. So let one of you, practice how to present part 2 to us in between 15 to 20 minutes. And we can then, I hope in your own case you have criticism. Let me
Yeah,
see. Do
we
you
did
have
small critics, sir.
Eh? Did you criticize each of the theories?
We did a general criticism, sir.
General criticism. Okay, work on criticizing each theory.
Hello, sir.
I say work on criticizing each theory.
Oh, okay, sir. Okay, sir.
You don't need to amend your writing, but anybody who is going to present amongst you should be able to tell us pros and cons of each theory and
Very
what
well.
aspect of
Very well, sir.
law of contract does each theory explain? Okay? Because we
Very well,
won't give
sir.
you more than, we will start early next week. We start by 5 on the dot, and we will not spend more than 30 minutes on
Okay, sir.
on your topic, so that we can take another topic. When we move to the last group of subjects, we subdivided them into many parts, but we can be taking 2 or 3 in each lecture. We will finish before the end of July. I can assure you of that. Okay?
Yes, sir.
Okay, sir.
That's
Noted,
noted,
sir.
sir.
Yeah.
Noted. Thank you, sir.
Look, comes class.
Okay, go to class. More like very patient. I don't know. How do you do that now? Okay, turn this to make it come. Which is it down for? Ah, why now? Do like this. Do like this.
No problem.
Just to be able to see the pictures properly. They should tap on pa. Yeah, pa. Okay, finish now.
Sir, is anyone still presenting, sir? So are we done for this?